Welcome to the panel Correcting Wrong AI Data. Can the right to rectification be of help? This panel is organized by Open Universiteit, based in the Netherlands. My name is Dr. Andreas Heuselmann, and I'm an assistant professor of privacy and data protection law at Open Universiteit. I obtained my PhD on AI and the fundamental rights to privacy and data protection in Leiden roughly a year ago. I'm the moderator of the panel, and I'm excited to facilitate the discussion of a so far underexplored data subject right. The constellation of the panel is promising, with an interesting blend of representatives from academia, legal practice, and the NGO. Before getting started, I ask each panelist to briefly introduce herself and state the interest in the right to rectification. Stephanie, since you're the initiator of the panel, I would like you to kick off the introduction round.
Thank you, Andreas. Good evening, good afternoon, everybody. I am Stephanie Rossello. I am currently pursuing a PhD at Open Universiteit in the Netherlands. I'm a colleague of Andreas, and KU Leuven University in Belgium. And my PhD is, on what? The very same topic of this panel. I started the journey 2 years ago. And I'm focusing on, as Andrea said, the right to rectification, which I find in academia to be quite underexplored, contrary to other data subject rights, such as the right of access or the right to erasure. I haven't seen much publications on this topic. And I also think it's a very timely topic when it comes from a societal perspective, because we don't really exactly know how to apply it when it comes to AI inferences. So, as I said, I'm halfway through the journey. I've had the opportunity so far to focus a bit on what the notion of accuracy means in the context of this right under Article 16 of the GDPR, what rectification means, especially at a national data protection level. But I still have many questions, maybe more than when I started the journey. And I thought this was a good opportunity to discuss some of these very thorny questions with an expert public and expert panelists with different backgrounds. So thank you for being here, and thank you for being here.
Thank you, Stephanie. Gloria?
Yes. Hello, everyone. I'm Gloria González Fuster. I'm a research professor at VUB, the Free University of Brussels, here in Brussels. I am doing research on digitalization and a Europe of rights and freedom, so everything concerning everything that is digital is interesting for me. I think the reason why I was invited to this panel is because many years ago I wrote a paper about inaccuracy, and you have the right to get your data rectified in the sense that you want data to be inaccurate. That was the main reason. Now, the reason why I was very glad to accept the invitation is because I keep working on data subject rights, and specifically there is a subject that I think it's very interesting, at least for me, is the question of gender. Can we rectify our gender data? What is accurate gender data? I have been thinking about this for some years, and now I'm very happy there is some case law about this, so it seems it's a real subject, so that's my main take on this. Thank you.
Thank you. Glanti?
Hello, everyone. I'm Clancy Sardelli. As you heard, I'm here representing NOIB, so we are a not-for-profit organization based in Vienna. We were founded by Max Schrems, and why I'm here in this panel today is because we are currently pursuing cases regarding the right to rectification. We have currently 2 pending complaints, both of them against OpenAI. So the first one we have is with Max Schrems as the data subject regarding his date of birth, and it was the first right to rectification case that we actually lodged and was public, so far as I know, in Europe. And the second one we have was rather recent, in March. So we had a data subject come to us with a case of a murder scenario. So a Norwegian citizen actually prompted ChatGPT, who am I, he asked, and ChatGPT replied that he was a murderer of his 2 children and attempted murder of the third one. So there goes my interest into being here today.
Great. Thank you. Anouk.
Good afternoon, everyone. My name is Anouk Fouquet. I'm a data protection lawyer based here in Brussels. I'm also academically active as a teacher of a GDPR course to law students at the University of Leuven, where I'm associated to the Center for IT and IP. I'm also the author of a data protection handbook in Dutch, which is quite often cited by the Data Protection Authority in Belgium in its cases. Reason why I'm here is because I would like to also have a look at the side, which is, I think, in these types of conferences not always touched upon, from the businesses. I assist multinational clients in making sure their AI systems are compliant first and foremost with the AI Act, but also assist them in questions with regards to data subject rights, such as the right of access and the right to rectification.
Thank you. Excellent. Could we switch to the slides, please? So finally, from my side, a brief note on the approach. We will address the question posed in the panel's title by means of provocative statements related to 2 themes, the scope and enforcement. Each panelist will react to the statements displayed, and we will ensure that sufficient time is left for audience questions. Okay, then let's start with the first statement relating to the scope of the right to rectification. The right to rectification does not apply to human opinions and AI inferences. Stephanie, may I ask you for a first reaction?
Yes, and maybe please interrupt me, because I overspeak.
I will.
Yes, do so. So I'll kickstart on this statement. Short answer, I do not agree with the statement. There's also a reason why it's provocative. Maybe before I detail why I do not agree with it, let us briefly, without going too much into the philosophical approach, clarify what we mean with facts and opinions in this specific context. I have found this statement quite often when I was researching the right to rectification in contemporary data protection scholarship, early data protection scholarship, and case law on the right to rectification. And what I see as a common thread in these sources is that they refer to facts as personal data that can be proven to be true or false. So something where we can agree that there is a objective benchmark against which to evaluate the accuracy. And opinions would fall into the category of data where it is more difficult to prove whether or not they're true or false. This empiric verifiability element would be what is present in the facts category or personal data in the form of facts. Think of the easy cases like names, email addresses, postal addresses, and would be absent when we talk about personal data in the form of opinions. It's a bit of an oversimplification, but I think it kind of gives you the idea for the context of this statement. Then why do I think that it is wrong? Well, simply because there is nothing in the text of the GDPR that supports this, and also not really in case law on the subject, CGU case law. I think that the concept of personal data is broad. It also includes assessments. If you look at Article 16 of the GDPR, it is not limited to factual inaccuracies, whereas this is, for example, something that you do see in national data protection legislation predating the GDPR. That was, for example, the case in the Netherlands in the wetsbeschermingspersoonsgegevens, which implemented the DPD. And on top of that, I've also found case law that applies this right to opinions, but then I think we have to be specific because when we talk about the right to rectification, maybe we have a tendency to think about rectification in the sense of replacement of inaccurate data with accurate data. Whereas if you look at Article 16, it actually encompasses two different rights. The very confusingly called also the right to rectification of inaccurate data, but also that is the first sentence of the article, and then the right to complete incomplete data. And when it comes to opinions, I see, on the basis of the research carried out so far, that the right to rectification is being interpreted more as a right to add the data subject's vision to the alleged inaccuracy instead of replacing the alleged inaccuracy with the data subject's vision. If I have maybe just another minute, that being said, something that I've also found out when doing research on the interpretation of Article 16 at the level of national case law and national data protection authorities, because unfortunately at the EU level there's not that much. We have now one case, the Deltits case, which I was very happy about, but other than that, again, not really a lot, is that we have to, if we are invoking the right to rectification against assessments, we have to be wary that we might stumble about on the hesitance of national courts and data protection authorities. Why? Because assessments, and here I'm really talking about rectification of assessments on the basis of their substance, are very often linked to decisions that can be contested at a national level through other means than data protection law and through other procedures than the one foreseen in data protection law. So one example would be, for example, a data subject that is asks the rectification of his qualification as not being capable of working. That assessment is then used as a basis for a decision in the social security sector. What I see is that national courts, and so far I can mainly speak about the Netherlands and administrative case law, have a tendency to say, aha, I'm sorry, this assessment is something that actually forms part of a decision that is specific to this national legal area, social security. I've seen also other areas, fiscal law, for example. So you should not use your right to rectification in this case. You should use those other venues. So we have to be wary of this intersection, of this possible overlap between data protection law systems of enforcement and data subject rights and national legislation that often also sets the normative standards for accurate reasoning. And I think I will.
Thank you, Stephanie. Yeah, an opposing opinion from the panel, Gloria?
Not an opposing opinion, is it? Okay. So
Yeah.
I agree that you're right that the statement is wrong, but just coming back to this fact that some national courts might think that you cannot use the GDPR if there is another way of doing things. I'm not sure this is really the best answer. We take this Deltits case, which is about asylum seekers and transgender identity, and they're using the GDPR. Of course, if you take this very narrow view that you can only use the GDPR when it's really about data protection as such, then we are a bit lost. I just wanted to say something about this overview that you have done of the scholarship and that you have found these wrong statements of people believing that this is right, and I'm already looking forward to read your thesis. But I was thinking myself in the past days, what do I know about the past ideas, the original ideas about whether the right to rectification applies to all of this? And I found in some Swedish debates from the 70s that I don't know if you know about this notion of soft data. Have you heard about soft data? So this is soft data. It was very important for them at that time. And I think we are not talking that much about soft data, and I didn't like the term when I saw it because it reminded me of soft biometrics, which I think is a very boring conversation. But soft data is interesting because it was really, I think I found a definition. It said it's facts or statements that look like facts but are actually judgments. So it's not opinions, but it's a judgment, a decision, as you're saying. And there was some reflection to be actually put in the law that soft data are covered by personal data. And they came to the conclusion that actually no, because there's nothing saying it's not personal data, so we just leave it there, and we will check for every case whether this applies or not. So I'm just sending you to also this list about the soft data. Thank you.
Okay, thank you. Maybe relatedly a question, to the panel. Often I've read that some scholars actually argue that you cannot rectify infer personal data under the GDPR because they constitute opinions based on, for instance, novel case law. And my question, I cannot refrain to completely keep philosophical questions out, but my question is not a bit premature to argue that output or AI inferences themselves constitute opinions.
Okay, I think it is completely premature to consider this because, of course, as we know, artificial intelligence as an umbrella term and both as different kind of technologies that are included in it is it's kind of excuse me, it's my first time on a panel, so let me gather my thoughts a bit. So it would be completely premature because AI does not have conscience. So AI is not human. So therefore it cannot form an actual opinion. It could be more, I was thinking about how could we have a different term, or how could we phrase this differently in order for it to work? And I think that the term that is mostly used right now, so AI outputs, is much more accurate than the actual saying as we have an opinion. And also about the previous statement, I am with agreement with the previous two co-panelists. I would also like to mention some other more concrete examples. So the first one would have to be an analogy to the Dun and Bradstreet decision by the CJEU, where we had credit scoring, and credit scoring is an assessment. So why not have an assessment that is kind of produced by an AI system be rectified? It could be as if we create two kind of different tiers of information. So we have within personal data, so personal data that are created by humans and personal data that are created by AI, and therefore creating two different standards. I think that is completely false under the GDPR.
If I may quickly react to that, it's not per se the distinction between personal data created by humans and personal data created by systems, because humans can also make opinions, and that's my question. Why the specific focus on, well, it's not really a question, but there's now a specific focus on opinions based or outputs from AI systems, while at the same time we've known all along that there are opinions being made by humans. So actually this is not really a new question to discuss. Of course the scope perhaps may be different, but I think here with regards to systems making outputs, at least there may be some reasoning behind it that we can verify or that we can inquire about. Whereas if you would go to your local municipality and a decision is there taken about by someone behind the desk there, it will be way more difficult to have a rectification of an opinion like that. So. In addition to that, just quickly, I wanted to say that in Belgium, I think what you found in the Netherlands with regards to it being difficult to have opinions rectified, I think the same is true in Belgium, although our data protection authority has been a bit more forward-going with regards to a case where the fiscal authorities had indicated an accountant to be a straw man. during an investigation, and that accountant tried to have that statement rectified, whereas the DPA, the Belgian DPA, said that there should indeed be an additional comment that could be included in the file. That was not followed by the Brussels Court of Appeal. The Brussels Court of Appeal said that the Belgian DPA has no role in deciding in a fiscal case whether someone's a strawman or not. So no right to. The Court of Appeal seems to say that there is no right to rectification there.
But did they say this is an opinion? I'm a bit still confused about who says that something is an opinion. Was that an opinion?
About the strawman?
Yes.
It's an opinion about the inspector doing the case.
And they said, it's my opinion, because I suppose you are not going to pay the taxes because somebody has the opinion that you should. No? It's either yes or no, I don't know.
It was an assessment.
It was
yes.
Made by a fiscal.
Yeah, and still during the investigative phase also. So it was because apparently in Belgian law, when you conduct a tax investigation, you have to inform the subject of that investigation at a certain point in time to make sure that you get a longer period of time to investigate the fraud. And because that communication had been done to the subject of the investigation, that person's accountant, I suppose, found out that he or she was mentioned as a strawman.
Okay, so I think there will be more time needed to discuss this. Also, to this discussion, opinions, value judgments, for instance, what can you rectify? But we'll leave it for now, and we'll go to the next statement that relates to enforcement. Technical impossibility to rectify is a valid reason to exempt the controller from rectification obligations. So Anouk, you're a practicing attorney. I would like to invite you to reflect on this statement.
Thank you, Andreas. And I think this is a very timely and valid question. Can a controller actually rely on a technical impossibility to avoid rectifying personal data? And I think the answer lays somewhere in the nuance. So let me quickly walk you through the legal framework and some case law, including I think a good Belgian example. Okay. And before, perhaps also let me start by saying that this, I think this issue has gained prominence in light of recent discussions. As you mentioned, there's indeed the Neub case in Austria with regards to the right of rectification of incorrect data in OpenAI's ChatGPT, where OpenAI, if I'm correct, is arguing that it's impossible for them to rectify a specific piece of information, except if they would block all information about that person. And then OpenAI is arguing that that would violate their freedom of information and the right to be informed of the public. So what's the legal framework? As has been mentioned, I think the right to rectification is clearly established in GDPR in Article 16, which says that data subjects have the right to have incorrect data corrected without undue delay. So based on Article 16, there's little room for debate, I would say. That being said, Article 16 is clearly intertwined with Article 5, paragraph 1d, so the right, the principle of accuracy, which includes that data controllers should take every reasonable step to ensure that inaccurate data is rectified. And then, of course, you also have Article 25, paragraph 1 of the GDPR, which includes the principles of data protection by design and by default, which allow data controllers to consider factors such as cost of implementation, context of processing, risks to the rights and freedoms when deciding on measures that should uphold data protection principles. So you have that legal framework, and what's interesting to see is then that there are some authors now saying that the Google Spain case law from the European Court of Justice concerning research engines should apply mutatis mutandis to general purpose AI systems. And in this view, they're saying that when a removal request is not granted, the data controller should take make every reasonable effort to ensure that incorrect data is rectified, and then comes the Google Spain case law, within that data controller's responsibilities, capabilities, and powers. So is there room for technical impossibility in the GDPR? I think in theory, perhaps. The GDPR indeed seems to leave room for the fact that a data controller is not able to rectify incorrect data despite every reasonable effort. In practice, I would be very careful. I think the burden of proof on data controllers is really high. Data protection authorities will clearly scrutinize claims in this regard, and it's clear that the threshold cannot just be mere effort or mere cost, but that there should be something close to actual impossibility. And then if I can quickly still refer to a Belgian case also here, which involved ING, which is one of the major banks in Belgium. They had received a data subject request from one of their customers to include an accent in the customer's last name, which the bank could not comply with because their legacy IT system dated from '95 and was unable to include accents but could only use capitalized terms. There, the Data Protection Authority, so the case came before the Belgian Data Protection Authority, and the authority said, well, just invoking technical impossibility will not will relieve you from your obligations, so you'll have to comply with the request to include the accent. It then went to the Brussels Court of Appeal, and that's interesting because they often delete decisions from the Belgian Data Protection Authority, but this case it was upheld, the decision. And it's interesting because the Brussels Court of Appeal agreed that Article 16 is unconditional, that there's also an obligation of result to comply with a rectification request. But at the same time, it also referred to Article 5.1d, that a data controller needs to take every reasonable step to ensure that data is accurate. And if you then see that the court referred to the fact that apparently the government is able to include accents on your national ID card. Well, if the government can include an accent in an ID card, then it can be then you can be sure that a well-functioning bank should also be able to include accents, and that is a reasonable step to take.
Okay, thanks. I like the comparison. So I've seen Gloria would like to react, and then Cleante, I would like to ask you, because you have first-hand experience, for instance, what was then the, let's say, the alternative offered by OpenAI rather than rectification? But Gloria.
A little thing to complement the answer, and just a little rectification. I think, I'm not sure anymore, but I'm originally from Spain, and you are referring to Google Spain, and I think, well, great, Google Spain. But I think the case they're referring to is not Google Spain, but just Google. It's not Spain, always Google Spain. There are many Googles, and so that case is not Google Spain. But just coming back to the statement, you mentioned many provisions of the GDPR, and you did not mention the two provisions that I think come to my mind first when I read this. One is the obligation of controllers to facilitate the exercise of rights. I think that is an obligation. They have to facilitate the exercise of rights, which means you might have to devote some energy to put in place the technical measures to actually make this possible. And then, indeed, the general obligation to just put in place all the organizational and technical measures to make sure that you comply with the GDPR. I think these are, in addition to all the provisions that you mentioned,
Article 24,
to all the provisions that have to be mentioned.
Thank you.
Okay, so about our case now. So far we have two cases. The first case is currently being handled by the DPC, as well as the second one. So what OpenAI offered was at first to block the information from ChatGPT regarding the birth date of Max Schrems, which was incorrect altogether. However, of course, as you can imagine, we could not agree with that. And what their thinking was that, of course, there is a right to inform the public and to keep them up to date with what's going on. However, I think that the right to information could also, why not, be combined with the right to accuracy? Why not the public be kind of informed of the correct information? So I I think that we are currently at the stage of submissions, and the case is still pending. So I cannot, of course, say more. However, yes, I think that the answer that they secondly proposed was only we are working on it was not enough. And one other thing, I was looking last week for solutions for the right to rectification, technical solutions, and I'm not a technical expert, I'm a lawyer. However, there is this really interesting paper that I would like to point out, and for the audience as well, from the support pool of experts by the EDPB, that points out the direction that current research has some tools, such as fine-tuning or retraining the model, maybe not for its rectification request, but maybe on a mass level. If you have gathered, for example, 100 requests, why not kind of retrain it on a mass scale at a later date? Because sometimes the argument that these companies put forward is that the cost is too high to retrain the model. So why not think a bit ahead and think that the complexity of the case could require a bit more of an extension of the GDPR that the GDPR allows, and give them that leeway to actually comply. So I think that we can find some sort of common ground.
Okay, thank you. Maybe Stephanie, I have a question for you. I mean, obviously you can also just add, but I think we could also be rather pragmatic and say, well, if rectification not possible, just delete it, please. So would that be the right to erasure? Would that be an alternative?
Yes. So that that is actually a question that I am researching now. So there is an extremely big link between the right to rectification and the right to erasure, which I think is also underexplored. If you think at how these data subject rights were formulated under the DPD, then you see that there was rectification, erasure, and blocking of data. They were not linked specifically only to the inaccuracy and the incompleteness. They were more seen as remedies that, depending on the context, would be the most appropriate ones. And to answer your question, I actually think that sometimes you can interpret rectification as erasure. So rectification does not necessarily have to mean, as I said, only replacement of accurate data with an accurate one. It can also mean that you're just erasing the inaccuracy, and that this is the only measure that is needed in order to correct the image of a certain individual in the given context. When we are talking about the cases lodged by NOIB, I am wondering whether OpenAI has offered the possibility to just adapt the language with which it is answering to the prompts. So rectification as in adding up uncertainty to the answer that is being given, rather than presenting something as a matter of fact, as of being true, like this is Max Schrems' birth date, but presenting it as something that is more contestable, that clearly communicates to the user that it is only an estimate of what the system thinks is right or wrong, but it is not necessarily correct.
Simply put, not at all. So, so far, we have two arguments that I say are both to the extreme. So, one argument is we have the right to inform the public of the wrong information, and the other argument is we technically cannot do that yet. We are working on it. So, no middle ground whatsoever.
Okay.
Gloria, may I ask you, do you think that adding, like complementing the output of the AI model, would that, in your view, would that suffice for OpenAI actually to comply with a rectification request?
I'm not sure really if this is the solution. I think the question is, could we extrapolate the case law indeed about Google search engines to this? Then the answer will not be in those terms, like just giving another picture, basically, but more if manifestly it is not the right birth. It's not that you have to say it's contested whether Max Rem was born in here. Maybe it's not contested at all. It's just that this is the fact. And as if the moment that they know that manifestly it's inaccurate, they should just stop giving the wrong information. But I just wanted to emphasize this point that the right to rectification, the right to erasure are very much conflicted, I think, in the minds of the legislator, possibly, but really in practice, in cases. I've been reading like complaints that people, when they go to the DPA, and perhaps originally they tried to exercise Article 16, but they wanted an account to be erased, and I said, it's wrong, the internet is wrong, but actually they don't want this to rectify, but to get rid of the account. So sometimes, and luckily, normally the answer is, okay, we understand what you want, and we try to deliver that. But it's very, yes, conflated or very, I don't know, one fits the other.
Okay, then I suggest we move forward with the next statement. Also related to enforcement, data subject might struggle to provide sufficient evidence when requesting rectification of AI inferences. So Cleanti, again, you have first-hand experience with NOIB. Did you come across this problem in the question of proof, burden of proof and standard of proof?
Of course. First of all, in our first case with OpenAI regarding Max Schrems' birth date, as I said before, this information was not public whatsoever. So maybe the data subject does not even want to give the correct date so that it should be corrected. Maybe they just wanted to be, just said that deleted what's deleted. But in the second case, what is very interesting is the fact that this scenario that ChatGPT created about this individual that was completely innocent and had no criminal, had not committed any crimes, he would have to give his criminal record to say that it would be clear. And there lies an even bigger problem regarding the legal basis of providing this criminal record, and also to a controller that's a private company. That is also very complicated under the GDPR. But I would also like to consider this a bit more from the scholarship perspective as well. So there are currently scholarship finds three main problems with this. So the information that is produced by AI cannot be always verified. So sometimes it's just an assessment, as we said, a credit score, or some sort of prediction on accident from an insurance company, or a prediction of an illness, or even a prediction that someone will default on their loan. So this is then not able to be verified by the data subject because, of course, it's an information that is regarding the future and not what's happening right now. So future events and statistical outcomes kind of can put this data subject right to the test. The second issue is that a lot of the times these assessments cannot be proven objectively. So we have affective computing, emotional affective computing. For example, Unilever, big companies as Unilever, use emotional affective computing, to understand how data subjects react during, for example, a job interview. And that is really interesting because sometimes these assessments and these judgments by these systems are false. And of course, emotions are not objective. So the data subject has no way to prove that this was wrong. And there is no more data other than it becomes a he said, she said thing rather than a legal discussion. And the third thing is that, of course, a lot of the time the data subject cannot be aware of the fact that there is wrong information spread about them. So if Max Schrems had not inquired ChatGPT about his birth date, or if Arve Hjalmar Holmen, our data subject on the other case, had not inquired who am I in ChatGPT, then ChatGPT might have well answered this to another individual, and that could be a huge case of misinformation.
Okay, thank you. So, Gloria, you already mentioned the Deltids case from the European Court of Justice, in which is the first time the European Court of Justice actually ruled on the right to rectification under the GDPR. And this is like a question to everyone from the panel. What does it reveal in terms of burden of proof and standard of proof? And does it maybe exacerbate the problem with regard to AI, rectifying AI inferences?
It's not about AI inferences, it is really about a very specific case. I don't know if people are familiar with this, because you are in the dark, we don't really see you. If you're following, are you falling asleep, everybody? Are you somehow familiar with this Deltids case? Yes, no, maybe, not really. I just explain, because it's a beautiful story. So it's an Iranian person coming from Iran, seeking asylum in Hungary, a trans person. Maybe they thought, it's a better future, but they stumbled in Hungary. And they were born originally female, but their gender identity when they come to Hungary is male. And at some point, they realized that in the register, officially, they are registered as female, and they want this to be changed. And Hungary has to comply with some human rights obligations that said you have to give the possibility for transgender people to have their gender changed, but they forgot to adopt the laws that actually allow you to do this in practice. So this person thinks, maybe with the GDPR I can get this information rectified. So they do a rectification request, and the answer is, okay, we can rectify the data if you provide some evidence that you have been undergone some surgical treatment and that you physically you were changed. And the person says, no, I don't need to provide this kind of evidence for the purpose of this rectification. And the question is indeed and then maybe we have not mentioned enough this notion yet, what is the purpose of this processing that is happening here? Depending on the purpose of the processing, we will need to prove something. And the interesting thing with gender is that now gender really, in the minds of people, is like different things. So some people really think gender, and there is some recent judgment from the United Kingdom, gender for the United Kingdom law, blah, 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 is the gender that you receive, that was assigned to you at your birth, but then this is discussed there, and the Court of Justice in Luxembourg says, really, that's not the question. It's not about what was your gender at birth. The question is, what is your gender identity when you actually enter into contact with the Hungarian? And that gender, to prove that gender, you actually do not need to provide any evidence of your birth, also any evidence of surgical treatment, but just some evidence that actually this is manifestly inaccurate, and then you get. So key message, it really depends on the purpose. That is the thing. And there is also this other Google case, which is not Google Spain, that I will come back to later, that is very much...
I checked it, it's Google Spain.
Is it in Google Spain? But I thought it was Spanish people, but okay, maybe we are just very keen on our rights. But so the name is the referencing of allegedly inaccurate data, and it's... Oof, no, I don't know. But it's Google Spain. Yes. And 2022, yes. And the key question is, how do you struggle a fair compromise between some burden imposed on data subjects and some burden on data controllers and keep this fair? I think the answer is more or less fair, but happy to discuss this.
Andreas, your question on the burden, we're still talking on the burden
exactly,
on the standard of proof?
on the burden,
yes.
and also just like what we can derive from the Deltids ruling in terms of standard and burden of proof.
Not that much. I mean, I'm happy that for the first time we have a judgment of the Court of Justice that does deal with the question of burden of proof and standard of proof under Article 16, because indeed, Gloria, the case you mentioned also talks about standard of proof and burden of proof in a specific context of the referencing request, so Article 17, and also the exemption to Article 17, right to freedom of expression and information, which was not at issue then in Deltids. But it doesn't really say that much to me. It says, yeah, the burden of proof may lie on the data subject. In the specific case, it did actually was put on the data subject. And then the standard of proof, it's very, I mean, it says accurate. The data subject should prove that it is inaccurate, not manifestly inaccurate in this case, which I think is a difference with respect to the case that you mentioned on the referencing. So in this sense, it is a bit more favorable towards data subjects. But also the two cases are not really comparable, I think. But then when it comes to what the data subject really has to prove, it says, well, all reasonable evidence that can reasonably be required in a specific context of the case. So we were still left to wonder. And in that specific case, I found it a bit far-reaching that the court still asked the data subject to reproduce the same medical examinations that it had reproduced already in the context of a different procedure, but against the same controller, it was the Hungarian Asylum Authority, to prove the inaccuracy. Why don't you just refer to that procedure? The controller already has that document. Why do you burden the data subject with? I mean, it was probably just a matter of using the same documents and handing them over again, but I don't think it sends the right message in this context. But maybe something that we have not addressed yet, I don't know to which extent there is time, the interplay between the right to rectification of AI inferences on one hand, right of access, and right to contest automated decision making, because I think that these three a bit come together when you talk about burden and the burden of proof. If you want to contest, rectification is a form of contestation. That's also, I think, one of the rationales of data subject rights, that you kind of can influence the image that is being given about you by the data, by providing input on it. When we talk about rectification of AI inferences and you want to contest the substance of the inference, as Cleanti said, sometimes you cannot prove whether or not the inference itself is accurate, but you have to go back to the procedure, the way in which the inference has been generated. And when this inference has been generated by an AI system, then you basically, it means that you need access to the underlying logic. So this is Article 22, access to the underlying logic in order to be able to meaningfully contest the assessment. And I think case law on Dun & Bradstreet and Schufa in a way also help us when we talk about burden and standard of proof and access to evidence of AI inferences, because Schufa especially has broadened the scope of what can be considered a decision that falls under Article 22. So the AI inference, if it is really has a determining role in a decision that significantly impacts the individual, such as a creditworthiness assessment that is then being used by a bank to decide on whether or not to grant a loan, that is a decision that falls under the protection of Article 22. And then with Dun & Bradstreet, we know that in those cases, we have access to not only the personal data and the profile of the data subject, but the entire underlying logic that needs to help you to be able to build your case against, to contest the decision and the inference. Okay. So I would consider that a step in the good direction.
Anouk or Cleanti, do you have some additional thoughts regarding to this statement? And otherwise, we will move to the last one.
No, not immediately. I was just thinking the Noib case with regards to the birth date, probably Article 22 wouldn't be very helpful there. But everything else, I agree with the Google TUR case. Indeed, was very helpful with regards to, I think, burden of proof and standard of proof. And then, indeed, with Deltex, we now have a little bit more specific information on that, on how we have to view that. Yeah. Okay. But it all ties in very nicely.
Yeah. Okay, then the last statement, also again with has to do with enforcement. To control the supervisory authority or data subject could act as the arbiter of truth, depending on the nature of the data to be rectified. Gloria, may I ask you to have a first step on this one?
And I will refer to always the same case, indeed, and I thought it was interesting that you said this case about search engines and right to the referencing is not comparable. It's not about the right to rectification, but we have, I think, this conceptual problem with the right to the referencing, that it is a liquid right. It is not really anywhere. It is erasure, but it's not really erasure. The original Google Spain was right to object. So where is it exactly? Is it really not that rectification? I think it is maybe not relevant for all AI inferences, but I would say probably for ChatGPT, to the extent that I have the feeling, I don't have the data, but most people are using ChatGPT in ways that, like they will use a search engine. It seems to be how young generations think. They don't Google things, but they just go and ask ChatGPT, what's my mother's name? Well, no, ask ChatGPT. Anything is, so to this extent, if we agree that it's a sort of way that people get used to get access to information, all this case law about the right to about search engines becomes relevant. And what this judgment says really is we cannot overburden the data subject, so as long as they provide some evidence, some obvious manifest evidence that the data is inaccurate, the data controller in principle has to just accept this. If it's not clear, the judgment says explicitly there's no need to open a debate. There's really no need to search for the truth. You cannot put this on the shoulders of controllers. Either it's clear or it's not clear. If it's clear, you just accept it and execute the request. If not, you leave it there and you say, well, but you don't open a debate, because the problem is if you do, then you cannot really be playing this role in facilitating access to information. So I think there it makes sense. Can we extrapolate this to everything? Probably no. But to the extent that it is useful in this context, I think we could expect a similar kind of reasoning from the court.
And within this statement, we actually mentioned the control, the supervisory authority, or data subject, but maybe also courts play a role in this regard.
Yeah, I want to say something on that, but just clarify. I think you are absolutely right in the sense that this case on that you mentioned on the referencing is relevant when we're talking about rectification and erasure requests of AI inferences. My comment was more related to the comparison between the Deltits case and the dereferencing case. But anyway, there is also something more that I wanted to add, but I forgot on what you said. We can continue the discussion perhaps later. Courts. Yes, I want to say something on courts. So this ties back to what I said, I think, in the beginning. When we are talking about who should ultimately decide on what the truth is, I mean, if the controller and the data subject do not agree with it, I think the GDPR tells us clearly, well, you go to an independent judicial authority. This can be a data protection authority, or it can be a real judicial authority, so administrative or judicial. One question that I have not seen tackled a lot so far is what we do with situations such as the ones that I've mentioned before, where a request for rectification, but it could be also a request for erasure, other data subject rights, falls under the scope of the GDPR, but also under the scope of non-data protection legislation. So national law that really sets the normative standards with regard to the accuracy of a certain reasoning, fiscal law, social security law, immigration law. There I've seen this tendency, and again, very much tied to the research that I've done in the Netherlands, administrative law, to just adopt a bit of a laid-back position and say, aha, I'm sorry, data subject, you know, your request for rectification can actually be dealt with under this other legal regime, social security, fiscal law. So I refer you to that legal regime, which sometimes also means another court. I'm not sure whether this is the way to go all the time. I think this creates a bit of it creates a hierarchy between the system of enforcement foreseen by the GDPR and system of enforcement foreseen under other national data protection legislation with which it may overlap. But I also do see that there might be cases and good reasons in which, you know, one court might have priority over the other. Cases in which there is, for example, courts with specific expertise needed, fiscal expertise, for example, the data protection authorities do not have. Yeah, I think this is just something that we need to reflect upon. Which court do we go to, and does the court have the necessary expertise to deal with the question? And I think that there is more that can be done under data protection law.
In the interest of time, I need to interrupt. You told me I should. I do it. Cleanti,
Yes.
yeah, what are your views? What are your thoughts?
I agree. However, I do think that this statement is the one that kind of created for me the most. I think it's the most problematic out of all. I think that, for example, with emotions, you really cannot have. You really have the arbiter of truth problem. Who is going to be the arbiter of truth? One solution that could also be useful here is just mentioning both information, so both the side of the data subject and the side of the controller at the same time, so that they can both truths kind of coexist. Truths, both sides of the story are said. So
you mean more like a complementary statement,
more of a complementary
which then
statement.
actually more relates to the right to have incomplete data completed rather
Yes.
than really rectifying
Yes.
data. Okay, Anouk, your view?
I had a typical lawyery response to this. I would say, I don't know exactly what you understand by the arbiter of truth, but I think, given that the fact that accuracy is to be determined based on purpose and context, I think this concept doesn't apply. It's a bit of a chickening out.
Yeah, I mean,
response.
actually we could make a case, and Cleanti mentioned effective computing, and then the inferred emotional state, and then related, for instance, if you use it in the context of an interview. But I will leave it with that, because I really want you to have enough time to ask questions. Wrapping up, the question, correcting wrong AI, can the right to rectification be of help? Based on what I heard, yes, but I think, in my view, this is my opinion. I don't want it to be rectified, and I will not allow you to rectify it or elaborate on it. But maybe we can extend the discussion during the drinks. So now, I will ask you to ask questions. We have 20 minutes left. If there are questions, please come forward. Indicate your name and your affiliation, and also indicate to whom you address the question. Yeah.
So my name is Laura Trechter. I'm with the Center of IT and IP at KU Leuven and the Open Universiteit, and also the State Archives. My question relates to something that I'm struggling for a while. So there is accuracy as a principle, and then there's the right to rectification as an individual right. Do they really fully overlap, or is accuracy the principle maybe fundamentally different than rectification? So we talked about obligations of means, obligations of result. Is one maybe an obligation of means and the other one an obligation of result? And is there somewhere the answer to the question, how useful is it in terms of AI interferences? And it's a question for the whole panel.
Well, somebody else wants to. Laura is also my PhD supervisor, and I think you know the answer that I would have to this question. But I would say yes, there is a difference. At this point, I actually see three things. I see the principle of accuracy. Well, now I'm really going into the nitty-gritty text of the GDPR. But so I see the principle of accuracy was just general principle. You have to make sure that the data that you are processing is accurate, which is something that you assess in light of the purpose of the processing, because indeed it is something that we have not really dealt with a lot. And then you have following from this principle, you have two obligations of the controller, I would say, that are related to it. One is to, when you're starting to process the data, to start erasing and rectify data that is inaccurate, which would also mean incomplete, which would also could mean up to date. And that would be covered by the second sentence of Article 5.1d. And that one does refer to reasonable measures. So when you're actually taking all these procedures and processing personal data at the bulk level, level, you have to make sure that, you know, or at an organization level, you have foreseen enough safeguards to make sure that what is inaccurate in light of the processing gets erased and rectified regularly. So I see this more as an ex ante obligation. But then let's say that you have taken all the reasonable measures that you can take in order to ensure that the data that you're processing is erased and rectified if needed. But there still is one data point that goes wrong, that is still inaccurate because you've just missed it. And because you're only required to do what is reasonable. Then the data subject comes to you, he uses his Article 16 GDPR right and tells you, I'm requesting the rectification of this data. There, I really think that you have no way out. You have to do it. And then again, what rectification means will be something that needs to be assessed in the specific context of the case. Can be erasure, can be replacement, can be adding up. But I do see this data subject rights, and specifically Article 16, as being an obligation of result in that sense. I don't know if...
You are the one doing the PhD about this, so we just listen to you.
I fully agree, and it's again based on Belgian case law. It's been explicitly stated that Article 5.1d is a best efforts obligation, so obligation of means, and Article 16 is a obligation of results. So we have it. It's Data Protection Authority, Belgian Data Protection Authority, and Brussels Court of Appeal.
And yeah, if we compare the principle with the right, I think we could also think about the burden of proof in terms of compliance with the principle, accountability principle under Article 5, paragraph 2. And then again, this the question we already discussed with the burden of proof when it comes to rectification of personal data. I think there it might also not completely match, like from a systematic point of view. So then, next question, please.
Thank you very much for the very fruitful conversation. I'm Tommaso Crepax. I'm with the Santana School of Advanced Studies, but I'm also currently pursuing a joint PhD with the University of Pisa and VUB. My question would be, do we always have to correct the wrong, or can we also correct the right? As in, all this is a spin-off of the right to informational self-determination, which is the right that I have, so the right I have for me to be presenting in the digital world in the way in which I want it to be, right? So it's informational, it's the limitation of your informational self, right? So do we have a right to inject some obfuscation, to inject some opacity in this transparent world, which would be more leaning towards the idea of privacy versus the data protection? Like, so do we have a right to inject to inject some obfuscation? Anyone, maybe Gloria has to.
I'm happy to reply to this, because I mentioned I wrote a paper a long time ago, and it's exactly about this. So the answer is yes, you do. But I have to say, I was mentioning the other day, I wrote this paper a long time ago, and I presented the paper at a conference, and everybody was super angry with me, and I thought, why are people angry? Because then I got insulted because they said, you want to lie, you want to, it's about lying. And apparently it's not okay to lie because somebody's watching you, and it's not okay to lie. And then, but I think you should be able to indeed lie or tell the truth that you think is relevant in a specific purpose, and that the GDPR doesn't say it's bad, and it's actually should help you. But if I can use an example, hoping it fits your idea. I was talking about gender, so in some contexts now gender has to be what was assigned at birth. It could be gender that is in your passport, but if you visit a website, sometimes you get asked, are you female, male, or whatever that you want to write. Imagine that on that day I want to say whatever, and I write whatever, and they ask me, they give me the possibility to say whatever, so I say whatever, and then I receive some communication, and I can see that I've been just registered as female. Can I go back to them and say, I want to have this rectified? Well, I'm perfectly fine being female, but for you, I want to be whatever. And then I was thinking, how can I do this? What would be the burden of proof? I think maybe I should take a screenshot, and insofar I take a screenshot and say, well, I told you, this is what I told you, this is what you should know, they should accept it. Are they going to easily accept this? I don't think so. I think whenever you try to exercise your rights, it's going to get complicated, and maybe they ask you for some ID document, I don't think it has been tested. It will be very complicated, but I think conceptually it should make sense that it is about the data that you think is accurate for a specific purpose, but to be verified in practice.
And Gloria, what happens, for instance, I mean, is there also kind of a conflict between like the controller's obligation to adhere to the accuracy principle, and then your right as a natural person to kind of disseminate also inaccurate data? What will prevail, and how would you approach this?
Not in this context. And then there is this other interesting case related to gender, which is the Moose case. To the extent that they really probably don't have a real lawful ground to really get this gender information. It's not that they can claim that they have a lawful ground to get the gender that is in your passport or your birth certificate or whatever. Maybe it's okay that they ask and you provide an answer. So then the question comes in of what is the lawfulness of this processing. It is more complicated. And this is the reflection that I was having about your questions about emotion. I think some cases that examples that were mentioned are a bit dubious to me if actually this will even be in accordance with data minimization, or maybe you can contest using these other claims. Yeah.
Okay, then next question, please.
Yes, my name is Leo. I'm here as representative of the UCAP, so European Council of Autistic People. And from the autistic part of the community, we are quite happy, but also quite afraid, concerned, because one of the examples is if we get videoed and people will infer emotions from us, I'm 100% certain that they will be wrong, because even non-autistic people are wrong all the time if they're not well informed. But another thing, and that's actually my question, can you interpret the training data as data that needs to be rectified? And let me clarify. Suppose people make a set of training data, and they use historic diagnosis of autism. Now, it's the case that in the past and still today, there's a very big underdiagnosis of autism because women, they need to comply to the social standards much more than male people. So if they would train with a very skewed, and the same goes for race, for instance, or there's a lot of examples where the training data can be manifestly wrong, not representative. Does that right for rectification also apply to a demonstrably wrong set of training data?
Thank you very much for these two questions. I think both lead to the same answer, what I would like to stress is something that I haven't done. So it's not only a link between the right to rectification and the principle of accuracy, but also other principles of the GDPR. And I think data minimization is an important one. When you're talking about emotions being used for a certain decision, maybe it's not only about those and all emotions being inaccurate, but those emotions being completely irrelevant in order to make a specific decision in a certain sector. And when it comes to training data not being representative, I would have the same hesitations, the same objections to it. But then perhaps more related to the interplay between the need to use relevant data, and if you tell me this training data is not representative, you can have an entire debate, of course, about training data not qualifying as personal data, but let's not go there. Let's say that a decision has been taken or an assessment has been made on you, which you want to contest, and you do not only have the right to rectification, you have other rights, which we can also all see as contestation, right? I think their data minimization does give you a pretty good ground to then invoke rectification. Yes, irrelevant criteria have been used in order to come to an assessment. It might be erasure that can also be applicable. So yes, I think there definitely are elements in the GDPR and the right to rectification that you can use, but not only the right to rectification, also broader than that.
Someone want to add something?
Just to mention the AI Act, there's this Artificial Intelligence Act. It's supposed to be the one that actually deals about this question of that whenever you have an AI system, a high-risk one, the training data is of quality. That would be, of course, it's more difficult to actually go and complain, but that's the legal solution.
Hello. Yes, I am Julie Vermeers. I'm a student at the VUB, and I'm currently writing my thesis on the right to be forgotten and large language models. So your insights have been very helpful. Thank you. And I had a question, and I wondered if it does seem that AI systems, it is impossible for AI systems to rectify or erase personal data out of their system. Is there a sense in finding them through the complaint system, through the DPAs, if it turns out to be impossible to delete or rectify data? What is the end game that you would go for?
Well, if I understood the question correctly, it was what happens with the complaint, or?
I think it's more a question if it turns out to be impossible for a controller to actually delete personal data, is there sense in finding them?
Yeah, that's a really good question. I think that in that sense, they should really kind of try to minimize the use of personal data within the system in general, because, of course, and what I wanted to say before as well was that the GDPR has been around since 2018, and it's not an excuse for companies to kind of say that, oh, well, we didn't know, we had no idea. You knew there is also privacy by design and by default, and you should be able to apply the law, basically.
I think going to a very much an extreme, but some that our clients are facing within other industries, is that indeed if your system is not compliant, and technical impossibility is not a valuable argument, then there are penalties, dwangsommen, which and you have to be compliant by a certain time, or you have to stop your processing activity, which will then be enforced by penalties if you don't comply. So the question is whether then technical impossibility is accepted or not. And if it's not accepted, then you're infringing GDPR, potentially AI Act. And then there's ways to order you to stop the processing activity.
Okay, thank you.
Hello, I'm René Mailleux. I'm also a colleague of some of you, and I'm also working on data subject rights. And I'm very much interested in the latter part of the conversation about the relationship between right of correction and erasure, and like more fundamental or basic principles of GDPR. And in that sense, my question is mostly related to when there's a complaint about rectification or erasure, should the controller and or an authority treat it as such, or always go to the question of the fundamental principles? And I think the NOIP cases are very interesting. Is the fact that ChatGPT is able to give such an answer not in itself almost a certain indication that the system itself doesn't is not in conformity with much more basic principles of the GDPR? As in, it's not really likely that this individual case of ChatGPT thinking that someone might be a murderer is an individual like exception case, and therefore it's more likely to be actually a sign that the accuracy principle is breached in total. And I was wondering, how to deal with that question, and also how Noib sees that and how you especially, Stephanie, also see that.
Definitely, and actually before we decided to pursue the second case with the ChatGPT murder scenario, we tried to reproduce, see if we could reproduce this result with a different person, and it was actually possible. So I think it's very much, and what we really stressed in the complaint was actually the principle of accuracy. So 5.1d, and it's in the requests of the complaint, and it's not only the right to rectification. So we wanted, from a strategic kind of point of view, to see how this issue can be tackled.
Yes, I completely agree with you, René. I think that the question is, how far do you want to go? Not only as a controller, maybe if you're confronted with OpenAI, you don't want to go really far because already a rectification request of one individual data point is problematic. But also, further step as a judicial or data protection authority, do you really want to sit back and look at the individual case, or do you want to see this as a symptom of a more systematic breach and go further and examine also those more systematic breaches under, perhaps not only the data subject right, but also the principles, broader principles. And I think it really depends on what the attitude is of the judicial authority or data protection authority that is examining the case. So on what their appetite is for going further. Again, in the text of the GDPR, I don't see anything that stops them from doing so. I have seen, it's funny how when we talk about rectification of opinions, you see both sides, a bit of the approach that you can take as a DPA or national court. You can say, sorry, other national legislation is involved. I refer you to that legislation, or you can actually, examine the complaint, see that there are other principles that are being breached. Fairness comes very often into play when you ask to rectify inaccurate inferences or opinions. Accuracy, as I said, data minimization, you can do that. There are good examples of that, and we can discuss about that in more detail later.
I just wanted to briefly mention security. I think security is an important one to the extent that not respecting the integrity of the data can be a data breach. And then there is the question, what's the relation between data breach and not complying with the principles of security? But it can be an interesting question.
If I can add perhaps another a view from the other side, I think transparency is also an important one. I would hope that, and I'm still reflecting on my thoughts here. I'm not an academic, so I don't have reflected on it that much yet. But we also need to consider that we don't want to stop any innovation either. So I'm thinking of what could be. I know this is not an easy way out. Like, I'm reflecting on how can we ensure that these types of innovative systems can be put in practice while they're not perfect yet. And perhaps transparency is an element that could help, that if these providers are transparent about what their systems can and cannot do, that perhaps we shouldn't go into the direction of, in addition to problems with right to rectification, looking at accuracy, security, and all these things, perhaps transparency can be a solution as well.
Okay, time is up. Time to conclude. Thank you very much for joining this panel. And now I would, I wish you a lot of fun for the remaining days of the conference. Enjoy the drink, and please join me in a big applause for the panelists.